Okay, what is the public embarrassment of a patent? Intellectual property comes from Article 1, Section 8, Clause 8 of the Constitution, giving Congress power to declare patents and copyrights. Thomas Jefferson was the first to call the patents a public embarrassment because it's a monopoly. We don't like monopolies. We want free and fair competition, but we allow it because it opens the door and encourages people to invent stuff. Abraham Lincoln had a patent in his name, and he says intellectual property couples the fuel of interest with the fire of genius. We want there to be a financial incentive to invent things. The Wright brothers had a patent in 1903 to 1910. They detailed the patent on airplane controls and revealed their entire steering mechanism. And competitors studied the patent, built modified versions, and eventually outdesigned the Wrights. This case goes to show the amount of innovation that arises because of patents. And even though they secured that one invention, it still bred new ideas and designs. On to the Coca-Cola example, telling waitresses not to offer other colas when a customer asks for a Coke. This is the basis for trademark enforcement. Failure to police can lead courts to rule that the trademark has become generic, and Coca-Cola would lose exclusive rights. To prevent Coke from joining this list, Coca-Cola must police its trademark. That includes telling restaurants not to use the word Coke to describe non-Coca-Cola or not serving other colas. Some trademarks that have been lost to non-enforcement include aspirin and light beer. Others at risk now are Kleenex, like, oh, I need a Kleenex, instead of, oh, I just need a tissue, or Band-Aid when we say or Band-Aid, or like when we say, let's do a Zoom call. People don't actually mean on Zoom. And Google, worst of all, has become a word in the dictionary to search, it means to search for information about something on the internet. Some defenses or policies include the mark not being distinctive, like the App Store or your own company that you made called Compact Engine Company. The names aren't distinctive and nobody will get to protect them in court. There's also little chance of confusion as a defense. Usually arises when different markets or with different markets, like Rolls-Royce USA that made clothing was confused with the car manufacturer because people can actually put car brands on clothing. But on the other hand, Ford Modeling was an agency that wasn't confusing and wasn't able to use the name, or they were able to use the name because it's very different. Explain the need to prove likelihood of confusion in a trademark misappropriation case. The biggest issue with trademark is, are customers confused? If they are, or they are likely to be, then it's a trademark infringement and you need to enforce it. The standard for liability is the likelihood of confusion. In the court case Kraft Foods versus Cracker Barrel 2013, Kraft had sold cheese under a Cracker Barrel logo for 50 years, while the restaurants are known for being on every major highway. So when the restaurant entered stores with their logo selling hams, the judge decided that it caused likelihood of confusion and made them switch the words to Old Country Store. To show infringement, it's not enough for the plaintiff to show that the marks look similar or that the defendant is using a similar name. The plaintiff must show that ordinary purchasers are likely to be confused. A fun case I read about was Starbucks versus Starbucks. Starbucks argued that Starbucks so resembled its Starbucks mark that consumers might believe the products came from or were endorsed by Starbucks or were affiliated. This is the classic likelihood of confusion argument. The two courts ordered that there was no infringement because likelihood of confusion was so minimal though. Next question is about big tech invading our privacy. Government intrusion has been well developed over the past 250 years. Although the right to privacy is not explicit in the Constitution, it is implicit in the Bill of Rights, but applicable to government only. Private intrusion is more limited, like the Wild West for our young generation right now. Privacy and convenience are an inherent conflict, and consumers are relying on self-regulation or hoping for future legislation. Big tech is taking advantage of all of our private and personal information and selling it to third parties to raise advertising dollars. And there's no limits on those third parties. And it's the balance between convenience, that we want convenience, and losing our privacy. You mentioned the crazy Alexa example where it states we don't listen or record anything until you turn us on, which is insane. And even with cell phones, they're pinged every few seconds to get signal, and that's convenient for us, but they track that ping for 5 years. They know everywhere we go. And we have ChatGPT stealing our YouTube videos to get more data in its system, but at least we're not China. We talked about this in InfoSystems class and how we kind of solve this, and we decided there needs to be regulation, basically. And that regulation should come in the form of a hybrid model between federal and the state government regulating AI and big tech, and Congress would pass overarching rules and leave the rest up to the states or individual companies and corporations. This is about the importance of HIPAA and COPPA. The right to privacy for consumers is founded in the common law. HIPAA provides for privacy of medical records. COPPA prevents collecting data on children under 13 without parental consent, and even with consent, it is heavily regulated. Weight Watchers is an example of them violating this. They noticed that the child obesity epidemic, and they began collecting data on kids under 13. They were fined $100 million because that sensitive information. YouTube had been targeting kids with ads, and they had to pay $136 million. We have high standards for this because this data is extremely sensitive. Children are at higher risk of manipulation or exploitation. Children are more easily influenced by advertisement, and they're more vulnerable to predators if their data becomes more accessible online. And there's long-term dangers of early data collection. They could build lifelong profiles starting from childhood and raise those ethical and psychological, that can raise a whole lot of concerns. Question 6. This is about the group of grads wanting to start an ice cream shop. So the Civil Rights Act of 1964 brings Title VII, and that applies to employers with 15 or more employees and eliminates job description based on race, color, sex, or national origin. However, you still can discriminate based on religion, sex, or origin if you have more than 15 employees, but not race or color. If you have a bona fide occupational qualification, like refusing to hire a Lutheran pastor in a Baptist church. I read more about the BFOQ, and it's a narrow legal exception that allows a business to hire only people with a certain protected characteristic when that characteristic is genuinely necessary to perform the job. Unless the shop is legally structured as like a religious organization, and unless the job duties specifically require someone to be a Christian, which they don't in the ice cream shop, they must follow the federal non-discrimination laws. But if the shop was like a nonprofit ministry, I think they could discriminate. I feel like it's a bad word, but yeah. Question 7. This is about the Billy Graham question. In his Modesto Manifesto, Graham stated that he shouldn't travel, meet, or eat alone with a woman other than his wife. I love that because it honors God, it honors your wife, it honors the commitment you made to her. I mean, he's not violating civil rights acts because the activities stated don't match the employer activities of hire, fire, promote, or compensate. However, in a work environment, refusing private meetings with only women, or like only mentoring male employees, excluding women from opportunities offered to men, then this could be considered unlawful sex discrimination. I read something online about the Mike Pence rule because he also does this, and how he treats employees differently, or he treats like women differently because of a moral code. But obviously women are not happy about this, and this could be found to potentially violate Title VII. I couldn't find any cases where men were punished, but it definitely seems to create legal risk. And I would say Billy Graham in his ministry setting was unlikely at legal risk, and I would follow similar rules for myself and just face the consequences joyfully. Question 8. This is about the two ethnicities and 5 races. This is obviously not a biological reality, but rather a social construct. There's one human race. The concept of 5 races came out of the European colonizers who were trying to colonize the entire world and claim that white people have higher value. We're all equal in the eyes of God. The goal of the concept of race was justification to colonize and take over the world, point blank. There are probably 16,000 ethnicities or more out there, and it's just the idea that one tribe knows they're part of a tribe and then they don't know they're part of a different tribe. And the U.S. Department still uses the same construct from the 1700s of like you have to fill out the same race and ethnicity structures in the past. Are you Hispanic or Latino? And then you have the 5 races. And they seem to ignore the fact that human DNA is 99.99% identical, and we are all made in the eyes of God. So thank you very much. Thanks for a great class. I actually learned a lot through this class, and I like the test format a lot because it forces you to learn. So thank you very much. Have a good one. Have a great summer if you have a summer. Peace.